on one afternoon I was riding the elevator and Mr. Doherty saw me in the elevator and advised me or informed me that there was a flood happening in their apartment. And I proceeded with him to go to his apartment to see what the source of the flood was. And when we entered the apartment, I noticed there was a lot of water on the floor. And I went around looking around where the pipes are, and noticed coming from the bedroom. And I noticed then it was coming from inside a closet where there are some heating pipes are. But the closet was full of things, all the way up to the top. So he had to remove all the things. When he did that, I noticed that there was a drain valve that was open or partially open, and that's where all the water was coming from. So I closed the valve and stopped the water, and then I called my helper, and he brought a vacuum, and we started vacuum all the water out of the apartment. And that process took maybe half hour, 45 minutes, and the entire time, Mr. Doherty was yelling at me. He was cursing at me, and he was really in my face. And I really got very afraid of him since that time.
Do you remember what he said to you, if anything?
Oh, can I say the words that he said to me in court?
I think we're all adults.
He called me motherfucker, or who are you? You came into he accused me of going into his apartment and opening up the valve of the water and causing the apartment to get flooded. And he just went on, fuck you, and tons of words.
Since that time, have you ever had to go have contact with Mr. Doherty?
No.
And why is that?
Whenever there's a work order, I try that my helper, my handyman, will take care of that. And it hasn't been a case where my handyman was not able to take care of it. But if there is, I would be afraid to go back to his apartment.
Okay. Did you relate this incident to management at Grandview?
Immediately.
And currently, do you have fear of having contact with Mr. Doherty?
Very much.
No further questions, Your Honor.
Thank you. Cross?
Very briefly, Mr. Collado. Yeah, approach the witness with a P1, Your Honor.
Counsel, just for the sake of brevity, I understand, if I'm correct, and you can correct me if I'm wrong, you're about to ask him whether that's anywhere contained in the notice to cease. I got it. Can we move on? Do you have any questions for him?
Did you call the police on this date?
No.
What date was it?
September 29,
So what year?
2011.
September 29, 2011. So that was a year ago.
Yes.
Has there... It's not in, but was there another incident that ever happened in the last year? Since then, has there been anything else that's ever happened?
Since then, no, but
Okay,
maybe...
no further questions.
Okay.
Thank you.
On cross, I have one question. Why hasn't there been an incident since then?
Calls for speculation. Anything else?
Have you done anything, have you changed your relationship with the Dohertys because of that incident on September 28, 2011?
I don't speak to them.
No further questions.
Thank you.
Okay, thank you.
Any additional witnesses? Thank you, sir.
I'd like to call Detective Tom Jones.
Tom Jones?
Yes.
Okay. Mr. Jones, you were sworn and you remain under oath, and please come and take the stand. Thank you. Good afternoon. Did you call Laney for me? Okay, thank you. Counsel.
Detective Jones, can you state who you're employed by?
City of Jersey City.
And what is your title?
Detective.
How long have you been detective?
Detective for 6 months.
And prior to that?
Police officer for 23 years.
All with New Jersey City?
Yes.
New Jersey City. Are you familiar with the building located at 3060 Kennedy Boulevard?
Yes.
And how do you become familiar with that building?
I received a letter from my chief that I had to address that building.
And what did you understand from that letter?
That there was a serious problem, a threat in the building regarding a male that is named in a letter as Travis Gilmore or Gallimore.
Okay, and that's going to be marked as P6. Counsel, have you had an opportunity to review this document?
I've not read it, but, Your Honor, can I
approach it?
February 23rd. Thank you.
Thank you.
Give me 1 second, counsel. Counsel, I'm having my clerk call to get us permission to allow overtime so that we can finish this until 5 o'clock, because I'm generally not assigned to landlord-tenant, and if we go beyond this, I have no idea when I can continue the next day of this trial. So I'm going to ask that you keep that in mind with your questions. I am quite capable of
Okay.
getting the point, so you don't have to belabor the issues. Okay,
Yes,
thank
got
you.
it.
Continue.
Mr. Jones, I've handed you a document exhibit marked with P6. Does that have a fresh recollection as to the letter received by your chief?
Yes, it is.
And what specifically in that letter were you sent to address?
They mentioned the Gallimore entering the buildings. I'm just going to read it right from the letter, if that's okay.
Sure.
Since this building is not safe, please enter a restraining order against Travis Gallimore. I'll get to the point where the landlord was claiming that Travis was stealing a computer on the 16th floor. No action was ever taken. A few years back, several women were beaten and robbed in the apartments. More recently, an 80-year-old woman was beaten and robbed in her apartment at Grandview. Gallimore is stalking his mother. He comes and goes in the building at will, usually using assumed names or just walking through the door since no security guard is ever present. It is only a matter of time before an elderly tenant here is beaten or robbed or even killed. Then he goes on about the landlord blocking legislation at City Hall. And he goes on about a bill that he's looking to, that the writer is looking to pass, Mr. Doherty. Hold on 1 second. The end of this, which is probably one of the most important parts, is it says Travis Gallimore is then shown on video on the 4th floor where he forces his way into an apartment where an elderly woman is alone. Okay, so based on this letter, I was sent there to address a safety issue at 3060 Kennedy Boulevard.
And what did your investigation reveal?
Okay, the first time I went there, I got to speak to Mr. Doherty and management. Mrs. Doherty wasn't there that first time that I was there. She came back later on. But the thing that was sort of left out of Mr. Doherty speaking to me was that Travis was Mrs. Doherty's son. So he made a big security issue, and as I'm talking to him, I'm realizing, wait a minute, this isn't a stranger in the building. You know who this guy is. Okay, so Mrs. Daugherty comes home, I speak to her. I ask her if she's threatened by her son, which in a letter it says, you know, a woman was forced into her apartment, and Mrs. Daugherty says, I'm not threatened by my son. So where does the part where he forces his way into an apartment where an elderly woman is alone, who is that woman? He's referring to his wife, but his wife is saying that never occurred. She's not threatened by her son. So from there, we go to a meeting where 2 council members are there from Jersey City Municipal Council. Mrs. Daugherty's there, and maybe 15 tenants, and they're talking about security issues in the building. At the same time, there's another woman outside with a petition asking for no security, like they don't want more security. So I'm in the middle of this mess, okay? More security, less security. Travis, Mrs. Daugherty, Mr. Daugherty. Okay. After this meeting, everything seems to quiet down. From there, you know, every morning I went to work, I look at, we have a CAD. He tells us all the calls that occur each day. So I pretty much just see, you know, see what crimes occurred. So I seen that there was another call at 3060 Kennedy Boulevard involving Mr. Daugherty. So I go back there, I view the tapes, you know, because it's a claim that Travis got into the building again, and, you know, he's the threat in the building. So I view the tapes, and I see Mr. Daugherty coming into the building with Travis. So now I go to the elevator, that is a camera in the elevator. No hostility between them. They're together going upstairs. So now I have Miss Carney switch to the 4th floor where they live. And here they are walking together down the hallway to their apartment. This is the same person that Miss Daugherty wrote a letter to my chief saying that someone's going to be killed in this building and Travis needs to get out. They go into the apartment. Now, if you watch the video, I can't be exactly sure on the time, but it's less than probably 2 minutes where I see Mr. Daugherty come back out of the room and he's on his phone, obviously calling the police. So my take on that was, am I allowed to state my opinion about this? Is that okay?
Yeah, ask what your investigation revealed.
Still, I'm sorry. Objection. The whole line of questioning is back to this, the issue I'm having with Travis Gallimore. We'll stipulate to the fact that Travis Gallimore may or may not, I mean, be a problem, right. But on one occasion, there was shown on the video, Travis Gallimore walks in behind Bill Daugherty, and one occasion, Miss Daugherty had a conversation with him, we saw it today, of him coming in and lets him in.
Right.
We'll stipulate that. So anything else you're testifying to?
Okay.
Your Honor, the objection is, I'm not sure the relevance of this testimony.
Well, the
what is
relevant-
an officer going to testify as to?
Thank you.
Outstanding.
The objection as to relevance is sustained with regards to the portion of the testimony that has just occurred in the last about 3 minutes. Does this officer intend to testify about anything with regards to the specificity as it relates to these 2 tenants, not Mr. Gallimore himself?
Yes.
Okay.
But it relates, Your Honor, to the multiple phone calls that they've made.
Made to whom?
Made to the police department.
Okay, that's not what we're here for. Whether they can call the police as many times as they want to. That has nothing to do with the building. You have to ask them questions as it relates to the disruption or the disorderly conduct as it relates to this. Has there ever been a disorderly conduct charge filed against the Gallimore, against Mr. Daugherty?
No, Your Honor.
Miss Daugherty?
No, Your Honor.
Okay. Anything as it relates to the disorderly conduct or infractions as it relates to the lease with regards to these 2 people, not Mr. Gallimore?
Officer, do you, based on your investigation, have you seen anything that would suggest that Mr. and Mrs. Daugherty has caused a violation of the quiet enjoyment of fellow tenants in the building?
Your Honor, objection. He's not an attorney, not a judge. He's no offense, obviously. I always respect.
The objection is sustained. He's not here to testify as a witness, as an expert witness. He's not been qualified as an expert witness. He's testifying as a detective who's had direct involvement and contact with these individuals. Any additional questions for this witness?
How many times have you frequented 3060 Kennedy Boulevard?
In reference to Mr. Daugherty?
In reference to the Daughertys.
It's probably 5 or 6 times.
And are all of them related to Travis Gallimore or just something else that you've been there for?
It's either Travis or it was just the overall security of the building.
Based on the overall security of the building, what was the investigation, or what was your purpose of being there?
As far as I could tell, there were no security issues in the building. I mean, Grandview is doing what they can, you know, with the cameras. There was my captain and a lieutenant went there and did a security survey for them, made recommendations, which they followed. The security issue is a big part of Mr. Doherty's anger, his complaints. And that's causing a lot of the disruption, because I can say this because I was there, I seen it, where he speaks out to the other tenants about security, and you know, there's a lot of people in that building, and you have a small group of people who are saying yes, but then you have a very large group of elderly people who are saying no, and now they're all upset that, oh my God, they're going to do this to our building, and it's just the overall, the people have anxiety over this very big security issue, and that seems to be the stem of what's going on here.
And have you found in your investigation any valid basis for Mr. and Mrs. Doherty creating this?
Well, I don't want to say that there's not, because a crime can happen anywhere. I can't say that the building is completely safe. My only recommendation to Mr. Doherty, which was by the letters that I've gotten from my department and Mr. Doherty, is that my opinion wasn't valued by him. Because in one letter he called me a dirty cop, and I'm on the landlord's payroll.
I'm going to stop you, sir. Anything else as it relates to this matter from this officer?
I believe just whatever he's going to continue to testify to.
Him being called a dirty cop has nothing to do with this. What I'm asking is if there's anything that has to do with... Do you have any questions of this officer that relate to whether or not disorderly conduct has occurred by these tenants, or whether they have done anything that he observed that related to a breach of the lease or violation of the rules and regulations? Any other questions for this witness?
Now, other than, does he have any first-hand knowledge of the Dohertys creating a interference with the management? If you have anything else to add to that?
No, just with what I witnessed from the other residents in the building about the way Mr. Doherty is handling his security thing and pressuring them to get more security. And it's elderly people, and they feel threatened by this.
And you've seen people?
I've seen it. I witnessed it. I was there for meetings.
Okay. How many residents did you
There's
see?
over. I heard Ms. Carney say there's 300 residents. At Mr. Doherty's meeting, there was maybe 20 people, and the rest of them were outside asking me what's going to happen.
Thank you.
I have a question. When you say that you personally witnessed the other people feeling uncomfortable by Mr. Doherty,
Yes.
is it that that they don't like the topic of the conversation and just want him to stay out of their faces about it, or is it that he is doing something to them that is hostile or violent or otherwise disorderly?
Well, they felt threatened by him pushing, well, we have to get security. We have to get security.
So they don't like how bossy he is?
Right.
Anything further than him being bossy?
No, Your Honor.
Anything, him being violent towards them, threatening him in
I have
them in
never
any
heard
way?
anybody say that.
Anything further?
No, Your Honor.
Thank you, sir. You can step down.
Thank you.
Thank you, Your Honor. Have a good day.
You do the same, sir. And congratulations on your promotion.
Thank you.
Any additional witnesses, sir?
No, Your Honor. Not from plaintiffs.
What's your motion, counsel?
Your Honor, the plaintiff has a burden even in this civil standpoint. They proved their case by preponderance. Clearly, based on the witness's testimony extracted today, there's been no testimony that, in my opinion, respectfully submitted to the court, that would have Your Honor rule in favor of just evicting my clients based on the testimony that's been presented today. At this point, I'd like to make a motion to have this complaint dismissed. There's been no violation of the lease. The notice to cease doesn't have half what was even testified today, but what was testified today does not, in their notice terminating the lease, nothing's been violated to a level where it would, or any level for that matter, where it would substantiate a breach of the lease agreement and therefore an eviction, the basis of eviction. conviction. So I'm respectfully requesting the court dismiss this motion before the defense presents this case.
Thank you. Counsel, I don't even think there's a need for you to respond at this point. Based on the information that I've heard so far, the court is satisfied that a motion for a judgment of acquittal would be inappropriate. The evidence hasn't been submitted. The documental evidence hasn't been entered into evidence for the purposes of the court's review, but this information that's been provided thus far does at least give the standard that's required in order to overcome the motion for a motion for judgment of acquittal, and therefore I'm going to deny your application and continue to proceed with the trial. Counsel, subject to the documents being entered into evidence, do you rest?
Yes, Your Honor.
Any objection to the documents P1 through P6 being entered into evidence, counsel?
No, Your Honor.
Okay, P1 through P6 are in evidence. Do you have witnesses that you'd like to call, counsel?
Yes, Your Honor. I would like to call Don Doherty.
Ms. Doherty, please come and take the stand. You've been previously sworn. You remain under oath.
Thank you. Ms. Doherty, I'm going to call your attention. You know, if P2 is going to be entered into evidence, may I see, use P2?
Counsel has P1 through P1, P2, and P6. Counsel has. Defense counsel has another attorney that's working with them. Hold on a second. Counsel, is that your associate in the back row back there?
I know, Your Honor.
Okay.
To see him, but that's not his associate.
You have another matter before the court that's on a post-judgment application. Which court did your associate go to? Do you know?
He went up to Judge Schultz and Judge Isabel.
Okay. Ma'am, you're Shanika Fields?
Oh, yes, I was.
He heard your matter upstairs already? Come in, please.
He would walk in and he reviewed the file when he came in at lunchtime. I called for the interpreter.
Are you representing this young lady, counsel?
Yes, Your Honor, I've represented her in the past.
Do you represent her on this post-judgment application?
Yes, Your Honor.
Okay. Ma'am, when is your lockout scheduled for?
Tomorrow.
No, you said the 12th. Today is the 10th.
Well, yeah, the 12th.
Okay. Then you're going to have to wait. Either you can wait and see if this matter is reachable today, or you're going to have to come back tomorrow because we're in the middle of a trial and I can't stop for that.
Okay, I can wait.
Okay. Then I can't promise you that we're going to reach you because there's another matter that's required immediately after this and I have to stop at 5 o'clock. So you can either wait or you can come back tomorrow. It's up to you. You can wait and take your chances, but if I can't reach you, you're going to have to come back.
Okay, I'll wait.
Okay, have a seat. Thank you. Counsel, continue with your witness, please.
May I go?
Yes, please.
Miss Doherty, I'm showing you what's marked as exhibits P1 and P2. Sorry. All right, you have a...
Just give me 1 second. I'm sorry. This is what happens at the last half hour of the court day. Mr. Interpreter, I see that you're here and you're here on the matter that I have to continue after this trial is completed. How long are you available till today?
Until 5:30?
Okay. We have to break at 5. So you're here. You can wait?
Yes, Your Honor.
Thank you very much, sir.
I didn't.
Okay. Continue, counsel. Thank you.
Thank you, Your Honor. Mr. I'm calling your attention to P2, which is the notice terminating the lease. You have it in front of you.
Yes.
Could you look at the second page? Second page referencing on May 11th, 2012. It's about 3/4 of the way down. Oh, it's correct. It's actually what I'm going to show you. Okay, I'm calling your attention to this paragraph, which starts off with, on May 11th, 2012, a fellow tenant heard loud voices in the hallway at 10 p.m., which included yelling and screaming the observance of William and John Doherty fighting with their son. Do you recall that incident?
Yes.
During that incident, did you call the police or was it the neighbor that called the police?
The neighbor called the police.
And what was the result of the police coming?
My son, I hurt my back. And my son wouldn't come out my apartment, and I keep saying, Travis, leave, because I hurt my back, I want to go to my bed. He wouldn't come out, so I said, come, Bill. When the tour will leave, then he will come out. And Bill go across.
When you say come out, you're saying come out?
Yes.
To leave?
Yes.
Go ahead, I'm sorry.
So what happened, my husband went outside, both of us, and my husband was speaking to a neighbor about the situation. And there's another lady across the other way, on our side, overheard my husband speaking to the neighbor.
But let me just interrupt you, but the conversation between you, or the dispute between you and your son.
Yeah.
Was there even a dispute?
No, just talking.
Right, and then when the police were called, what happened? Did the police take it?
When the police...
I'm sorry, let me just finish that question. Did the police come and take Travis Gallimore out of the premises?
Yes.
And so that's all that ever happened on May 11th? After that, after he was taken out of the premises, was there any further altercation?
With the neighbor speak to me downstairs.
Well, you can't tell me what the neighbors said, but the neighbor had other than the police coming and escorting Travis out, did anything else ever happen? Was
Yes.
there for any other reason?
Yes, with the police asking me for sex. What his name is? Tom Jones. He friend me. I have his personal phone number here.
All right. Well,
More than once he come to my apartment unannounced.
so he comes to. Are you testifying? Didn't ask you that question, but are you testifying here that
Yes.
the officer already testified? I don't think there's
Yeah.
anything to hurt us. You don't need to say this right now. So I'm sorry, just to save time, Your Honor.
Yeah.
Let me get right back to the P2. On P2, you see the next paragraph where it's, let's finish May 11th. On May 11th, 2012, was the whole basis of the police being called to escort Travis Gallimore out of the premises?
Yeah, but there was no noise when the police called.
I understand, but the police, okay, when the police came, did they arrest you?
No.
Did they arrest Mr. Doherty?
No, there was
Did they
no
arrest the
noise.
neighbor?
No.
They didn't arrest anyone, but did they take Travis Gallimore out of the premises?
Yes.
Okay, and that was it, right?
Yes.
All right. Other than Officer Tom Jones having that conversation with you after the fact,
Yeah.
which had nothing to do with this case,
Yeah.
correct? All right. So May 12th, the next day, right? Could you read see what it says on May 12th, 2012? Actually, I'll read it to expedite. Travis Gallimore, on May 12th, 2012, Travis Gallimore entered the building and proceeded to bang on Mr. and Mrs. Doherty's door for 2 hours. That's the first part. Do you recall that? Were you even home? Maybe that's the question.
May 12th? I'm pretty sure I'm not there. Most of the time I'm not home. I leave
Right.
10 in the morning and I
Because you're
come
working
at
all day,
night.
correct?
Yes.
So if he was banging for 2 hours, you would presume you weren't there, correct?
Yeah.
All right. And either way, he didn't come into your premises on May 12th, correct?
Yeah.
And you don't recall letting him in the premises, or do you don't recall Mr. Doherty letting him in the premises on May 12th, correct?
No.
Okay. Next. On the 14th, 2 days later, this was discussed with Ms. Carney. You were listening to this before, correct? Correct?
Yes.
Yeah. When on May 14th, it says Dawn Doherty positioned herself in the lobby in such a manner as to escort Travis Gallimore into the building at approximately 9 p.m. Correct?
More May 14th?
That was the day where there was a video we watched. You didn't
Yes.
get to see it. So let me rephrase that question then.
Yes.
When Travis was up on May 14th,
Yes.
Travis was up in the rec room, correct, on the 16th floor?
Mm-hmm.
And you had a dispute with Travis, correct?
I need to explain it to the judge and everybody, if you don't mind, Your Honor,
You can
what's
be brief.
going on, because all of this is a lot of lie. And
Tell me about why you let him in the building. Did you let him in the building on May 14th?
May 14th. I don't remember. I was going through so much.
Okay.
I was going through hell, and the landlord, them wouldn't do anything because they're trying to get something on me. 2010, he wasn't supposed to come there. They tell lie on me, and we go to court, and the court, I explain what's going on, and the court...
You don't have to explain all that
Yes.
to me, ma'am. That's fine. Any additional questions for Mr. Arden?
Mr. Arden, if the last question actually. From what you see in front of you when it's between the notice and cease and notice terminating the lease,
She doesn't need to do that,
Yeah, I
counsel.
understand. I just wanted to
Can-
be sure.
Let's,
No further
counsel,
questions.
would the two of you stipulate that only the items that are in the notice to cease are in the notice to cease, and if they're not contained in the notice to cease, they are not there?
I can stipulate to that, Your Honor, with the caveat that the notice of cease also talks about in general interference with management. And then
I understand that. I'm talking about with regards to the specifics. If it doesn't list the name of the individual specifically, can we stipulate that they are not in there? And that counsel makes the representation that anything not specifically alleged in the notice to cease, he believes is captured under the general statement that they interfere with management.
then I have to ask her some more questions. Ms. Doherty, just very brief, quick question. Pick up P2.
I cannot see I have glaucoma in my eye. I'm blinding out my eye, so I have problems. So if you could just tell me, I could answer the question.
Have you reviewed P2, this exhibit, notice terminating the lease?
Yes.
And do you recall anything at all in that document that says you interfered with management?
No.
And anything referring to you interfering with management?
No.
Was it all about Travis Gallimore?
It's all about Travis Gallimore, the make-up story. And
Right, so nothing in the notice terminating the lease has anything to do with you being, you know the landlord's trying to evict you as well,
Yes.
correct? And is it your position that,
Counsel, that's a legal argument that you can make in closing. She doesn't make the legal arguments. Do you have any questions for her?
no, you don't.
Do you have any cross for her
yes, Your Honor.
that you deem necessary and not repetitive?
Yes, Your Honor.
Please.
Ms. Doherty, how many times have you allowed Travis into the building since 2011?
I allow him because the police give him the okay. They said no letter from the court didn't send to him at the time about the mediation for him not to come in. So I allow him in. The police said as long as him come and him just getting him liquor grocery and going away and not bothering anybody, him welcome there. They give him the okay. So from that I
I'm going to stop because I'm just looking for a number. How many times have you allowed Travis Gallimore into the building since January 2011? If you can approximate, that's fine.
Maybe one time when they allow it, they said he could come. Because he didn't get anything by writing.
Stick to answering the question, please. Have you ever yelled and got into a fight with fellow tenants?
Me?
Yes.
I have it on tape. The tenancy I didn't bother her. I just don't get the chance to bring all of my evidence here. It's a setup with Lisa Connie. She hate me, and she just keep picking and going around and making...
You say Lisa Carney hit you?
Yes, she making story. I have it on tape. When everything over, I said to the tenant, do I ever bother you for my coming here? She said, no. All of this is
Ms. Doherty, you're going to have to talk slow because the
Yeah.
attorney doesn't understand your patois.
Yeah.
She did not say that
I'm
she
a
hit her.
Jamaican.
She said that it's Jamaican, and I understand it,
Okay,
but
I'm sorry.
what she said was that all of this is on the account that the building manager picks on her and keeps making up things over and over again, and that she wrote a letter asking whether she ever did anything to the other individual, and the other individual said no. Continue, ma'am.
Yes. I sent a letter to Lisa Connie. The time when we have problem with the lady is the one approach me and saying things. And then she run into Lisa's office. Both Lisa run out and she run into Lisa's office. And right away I know it's a case she's trying to make up on me. This is what's been going on. They just keep going at me and my son going at me. It's like everybody want to kill me. For what? I don't know what I done these people.
The testimony before from Ms. Carney talks about an incident that happened in the laundry room. Are you familiar with the laundry room?
Yes.
Are you familiar with the incident of a fight that you had with a fellow tenant?
It wasn't a fight.
What was
the
it?
lady, I was doing laundry, and the same lady came in and almost bounced me, and she said a dirty word. And me say, what's going on here? And then I sent a letter because the lady hacked up. I sent a letter to Lisa about it. But everything I do, Lisa turned it around back on me. And this was 2011. I have the certified letter them I sent to her, and they never replied to me. And then what they do, they set it up and fix it up for this year to come back at me and turn it around on me. This is what's going on.
So it's your testimony that it's Grandview who has some sort of vendetta against you to get you out of the building?
Thank you.
And is that your testimony?
Exactly.
And what and for what, do you know of any reason why they would have that?
Yes.
Why?
The first time, 2010, Lisa directly, my son went up on the 10th floor and sleep. And it become a issue. She said my son tried to steal the computer. She called the cop, we called the cop, and after the cop gone, Lisa Connie deliberately pick an argument with me and then go and file a complaint, say I threaten her. I went to court twice, say I threatened this lady. She didn't threaten me, I didn't threaten her. And even Ben, the super, filed a complaint that time from 2010. And this been going on and they just won't stop. They keep going at me for what I ever done to this lady. I don't know, she just suffer with hate.
And is that the complaint that Benjamin and Lisa had with you, was that what we discussed earlier that happened in October 2010 with
Yes.
the mediation agreement?
Yes.
And you agreed in that mediation, you signed that document?
Yeah, because I didn't want my son there.
And part of the agreement was that you won't have any contact with anyone from management except through third parties?
Yeah.
And have you abided by that?
She
Have you abided by that?
Yes, I do. I can explain about that part, what she said. I come there moving stuff and yelling. That's another lie she tell right there.
So your testimony is that everything that Lisa Carney has said has been a lie?
It's a lie. If I get, what you call it, a lie detective test, and she get one, it would prove. So she's a dangerous liar. She's very good.
So Lisa's a liar, but you're telling the truth?
Absolutely. I have no reason to lie. And I can't explain about that situation, what she talk about also.
But you admit that you violated this mediation agreement by letting Travis into the building?
The police give him the okay 2000 and this year, 12, when he start back to come in there.
So the police says okay.
I panic and I call them because I don't want any more problem with these people. So when I call the police, what happened? They come. My son explained to them, say he never get any paper saying him not to come in the building. And that work out that the police said, well, Miss Dorothy, as long as he's coming for a little grocery and not bothering anybody,
I don't really understand what you're saying,
come.
but I just want you to focus on my questions instead of saying what you want to say. You admit that you violated this agreement by letting Travis in, correct?
Because the police give him the okay. I have no control over that.
It's a yes or no question. You admit that you violated this agreement by letting Travis into the building?
No, because I
What's
did
the relevance?
call the police.
Stop,
and they-
please. Stop, please. There's an objection on the floor. What's the objection?
The relevance, John, it predates the notice to cease, it predates the notice to terminate the lease, it predates everything to do with this, the reason we're here today, Your Honor, this mediation agreement that has, and it has nothing to do with landlord-tenant relationship. It was a two cross complaints of harassment, and they came up with this resolution in the criminal court, and it has no applicability to today, so it's relevance.
The objection to the form and substance of the question is sustained. If you have another question that you'd like to ask her that's relevant to what you're trying to gain from her, you may ask that question.
I have no further questions for this witness.
Anything further?
No, Your Honor.
Then thank you. Step down, ma'am. Do you have any additional witnesses to your arrest, counsel?
Your Honor, I have to call
William Dart.
Sure, counsel?
No. Mr. Daugherty? No, I don't. It's going to be, based on the testimony, it's not going to be anything different than potentially what was already heard. So.
And I'm not rushing you, counsel. I'm just trying to find out whether there's additional information that you'd like to have Mr. Dougherty testify
And I know
about.
that, Your Honor, and forget about, it wasn't the time and brevity of today. It was just that I think about the testimony to be extracted today. We would rest.
Do you have any additional documents that haven't been admitted that you'd like to be admitted into evidence, counsel?
No, Your Honor.
Either side have anything they'd like to say in closing arguments that I haven't already heard in opening or during testimony?
I don't have, Your Honor.
Thank you. This matter was presented to the court as a trial for the purposes of an eviction hearing as it relates to NJSA 2818-61-1B and 61-1D, the first of which is disorderly tenant. The statute reads as follows: the person has continued to be, and after written notice to cease, so disorderly as to destroy the peace and quiet of the occupants or other tenants living in said house or neighborhood. The testimony of the plaintiff in this particular case was presented by way of two witnesses, the first of which was the on-site manager, three witnesses, the first of which was the on-site manager, the second of which was the superintendent of the building, and the third was a Detective Tom Jones. Lisa Kearney is the on-site manager who testified specifically with regards to the language of the lease and what it was that she notices or has observed personally, and the things that were contained in the notice to cease and or notice to quit. The substance of her testimony was that she received information from other individuals, namely either tenants and or the Doughertys themselves, and or her other staff in the buildings, who have indicated that the son of Dawn Dougherty, a gentleman by the name of Travis Gallimore, has been entering the building and causing problems. Travis Gallimore, for the record, is not a tenant on the premise, nor is he the subject of this particular complaint. The testimony has been that he was on a recreation lounge and a couch, interfering with a bingo game, at some point that he pushed a security guard, that he has signed in under different names, that he waits for other people to let him in, and that he follows behind other people when he's not telling them that he's going in to see his mother. None of this information was garnered by Ms. Kearney herself, other than her viewing some of the substances or instances, on the video camera. However, none of those instances relate to Mr. or Mrs. Dougherty. All of the instances that have just been named have been described as instances where he gained entrance in other ways, either through pushing people aside to get into the building, or going in with people by telling them that he's going to see his parents, or by waiting for them to let him in and following in behind him directly. Even the testimony with regards to the son lounging on the recreation lounge, there was no indication that on that particular day, one, that he was let in by either of his parents. Two, there was no testimony that they even were aware that he had been let into the building prior to this. Or three, that in somehow he caused an instance or problem with regards to him being on the recreation lounge. Nor was there any testimony to suggest that security had asked him to vacate the premises if he was there unlawfully or without the permission of anyone in the building. Moreover, most of the information that Ms. Kearney received as it relates to the things that I've just placed on the record were hearsay, as they were relayed to her by other individuals other than what she's observed on the video camera, which do not in any way relate to these particular tenants. Regarding the April 27, 2011 instance, it's an allegation that Dawn Dougherty yelled and screamed and called 911 for no reason. The subject of this was supposedly as a result of her attempting to move furniture, and because she was not allowed to use a cart or some object to assist in using that cart, she called for 911, and Ms. Kearney indicated for no reason whatsoever, calling 911, that she was yelling and screaming, and Ms. Kearney seems to refer to the words as yelling and screaming and compares that with being violent. However, when clarified, it was indicated that no violence of any sort was used, simply that Ms. Dougherty was yelling and screaming. However, contradictorily, it was stated in the notice to cease that Dawn Dougherty was behaving so badly that there was a necessity for the police to be called. However, the testimony that was Dawn Dougherty herself called the police. I don't understand how it can be necessitated for her to call the police in the notice to cease, but then she's the one who's calling the police for no reason. Then there was an issue with regards to a broken pipe where the tenant was screaming and yelling, namely Mr. Dougherty. The superintendent indicates that Mr. Dougherty was yelling and screaming and calling him names and saying rude things to him while he was there the whole time fixing the pipes. There were no allegations that he jumped at him, that he in any way used any violence, but that the superintendent felt uncomfortable, in his words, that he was afraid and that he would not go back to the apartment after that. That was one occasion, and he has not been back to that apartment since. On May 6th and 7th, there was an alleged altercation in the laundry room where a fight broke out between the tenant as described by Ms. Carney. Later, it was determined that there was no fight. There was a verbal altercation for which Ms. Carney has no information as to how it started or who started it. All she saw is that there was an altercation between the two. The testimony of the tenant was that the information was that the altercation was started by the other individual, that there was no fight, and that's all that happened. There was no police report filed. There was no charge of disorderly conduct filed against the tenant. It was simply a verbal altercation that occurred in a laundry room about something. The October 7, 2010 document, the mediation agreement, is only relevant in this court's view as to if it were to show some type of violation of either the lease agreement and or some type of disorderly conduct as it relates to the tenants in this particular matter. As far as the court can see, there has been no specific information as it relates to this particular individual and letting him into the building, except one occasion where it was noted on the video that the tenant was seen being let in by the, two. One by Mrs. Doherty and one by Mr. Doherty on April 17, 2012, and it appears on the other one, I believe, was May 14th, 2012. Those are the two times where the tenants let the individual into the building. However, on neither of those occasions does it appear that there was any disorderly conduct that resulted as a result of them letting them into the building, nor does the lease agreement specifically say anywhere that they are not allowed to let this gentleman visit them in their premises. The mediation agreement was simply a mediation agreement that was signed as a result of a dispute between Benjamin Collado and Lisa Carney with William and Dawn Doherty. Nowhere in that agreement does it say that this is now a part of the lease agreement and any violation of it will result in a violation of the lease agreement or the rules and regulations of the building, nor does it say that it will be attached as a rider to the lease agreement. It is separate and apart from anything that has occurred as a result of this particular matter. With regards to any of the information that's been presented, the court also finds noteworthy the testimony of Detective Tom Jones, who indicates that the substance of most of what happens between William Doherty and the other tenants in this particular building is the fact that William Doherty has concerns about the safety of the building and that he tries to probably a little feistily tries to boss people around and get them on his side with regards to his position about the security, which other people disagree with and don't want security in the building. The detective himself says that he can't say specifically that the building is completely safe and that it's not baseless. He indicates that he's been there 5 or 6 times to the building, that the 5 or 6 times have either been regarding Travis or regarding the security issues, not as it relates to disorderly conduct, as it relates to either one of these particular tenants. Ms. Doherty indicates that she let the tenant in, let this individual in the building one occasion, which seems to be consistent with the evidence that's been presented by Plaintiff's Counsel, which is the one day on April 17, 2012, reflected in the video. Disorderly conduct has to be reflected as both repetitious and excessive. It must be disorderly to a person of normal sensitivities. There's been no testimony by any tenants who reflect that they somehow have had their quiet enjoyment disrupted. It's only been the testimony of Ms. Carney, who has indicated by way of hearsay that other tenants may or may not have said this, but I can't consider it because it's hearsay. No other witnesses have come to testify that their quiet enjoyment in any way has been disrupted. There's been no disorderly persons complaints filed against either of the tenants in this particular matter. The only thing that's been described in this particular matter is the fact that they yell, and I dare to say that if yelling is disorderly conduct as described by these individuals, which is a fight between, a verbal altercation between a parent and a child or between spouses, I dare to say that everyone would have disorderly conduct filed against them because parents fight with their children verbally and husband and wives argue all the time. I yell at my children on a regular basis and I hope my landlord doesn't find that that's disorderly conduct. In this particular case, I do not find that the plaintiff has established their burden of proof with regards to disorderly conduct, and therefore that portion of the complaint is dismissed. I note for the record that the court is relying on Kellett versus Lewis, an unreported opinion, docket A-6619-97T2, an aptiv case out of 2000, which indicates that rude behavior, inflexibility, and onerousness are not admirable traits. However, the Act affords no remedy to someone who is forced to deal with a tenant who exhibits those traits. We are sympathetic to Kellett's plight. However, we must conclude that the proofs presented do not support an eviction for disorderly conduct. I agree. Onorousness is described as touchy, crabby, bad-tempered, and uncooperative. As I hear the testimony presented with regards to Mr. Doherty and perhaps Ms. Doherty, I could see how that could be interpreted as such. Having a woman speaking in patois, yelling and screaming down the hallways at her son to leave her alone when she has a bad back could be annoying to people, but it does not rise to the level of disorderly conduct. Having a gentleman who decides that security is a big issue when the other tenants don't necessarily feel that way and calling the police about it could be annoying, but it doesn't rise to the level of disorderly conduct. If they exhibit disorderly behavior, then that needs to be documented and it needs to be presented by way of evidence. That has not been accomplished to the court's satisfaction, and therefore that portion of the complaint is dismissed. As it relates to violation of any lease agreements or breaking any rules and regulations, the court has not seen anything that suggests that in any way any rules or regulations have been broken. There has not been anything specifically pointed to other than the mediation agreement, and the mediation agreement do not constitute rules and regulations of the lease or of the tenancy. If there was something in this agreement that said, and this shall constitute rules and regulations amended to and attached to the lease agreement, or shall hereinafter be referred to as, rules and regulations of the agreement, then perhaps so. But there's been no rules and regulations set forth on the record that indicate that they were ever advised that their son is not allowed into the building, not allowed to visit them. There's been no rules and regulations that have been set forth or placed on the record that indicate that their son is not allowed to lay on the couch on the 16th floor, the 10th floor, or do anything in the building or coming in and out of the building. Therefore, the court is not satisfied that that burden of proof has been met either. There's been no violation of the rules and regulations. However, I will state to Mr. and Mrs. Doherty, as I dismiss the complaint in its entirety, tread lightly, because at some point they're going to revamp these documents and you will be evicted should you violate any agreements that are in their lease agreement or their rules and regulations. If your son is a threat to you, file a restraining order. If you don't want him into the building, document that to your landlord and ask them to get involved and do something about it. However, you cannot do that and then on the other hand let him back in the building. If you're threatened by his behavior, don't let him in. Call the police. File a restraining order. I'm not giving you legal advice. That's what your attorney is for. But I'm letting you know that at some point they're going to do something differently. And one day they may be successful in having you evicted, and that would be a shame. So keep your voices down. Control your child. Have a good day. The complaint is dismissed.
Thank you, Your Honor.
Thank you.
I'm returning the documents to counsel. May I have the next parties in the matter that we need to continue? Come on up.